Joining us now is former Erie County DA and current civil attorney John Flynn.
And also defense attorney Barry Covert. Let's start with you, Barry. Your initial reaction to the verdict?
Because it came back so quickly, I really wasn't surprised that it was going to be the majority or not all of the counts being guilty. And it's impossible to read a jury, but what I do know is in a complicated case, 34 counts, not easy to figure out what the jury instructions are. They asked for them to be read back. They were out for really a relatively short period of time, and I would have thought that if there was some fighting and arguing that Trump should be held not guilty on some of the counts, that we could have had a few more days of deliberations. Maybe they came back and said we can't come to a conclusion, we're hung. But in this case, to come back this quickly, and given that much of the time was spent doing readbacks, and the readbacks seem to be favorable for the prosecution. You know, John will tell you it's a fool's errand to try to predict what a jury's going to do and read while they're out. But this case kind of was made easy by how quickly they came back.
Yeah, I think a lot of people felt the same thing.
John, your thoughts?
Well, I was surprised initially how soon they picked a jury. When this case first started, I was telling people that there's no way you're going to get 12 jurors picked and 3 or 4 alternates in less than a week. They did it in a few days. So now they come back, and as Barry said, the majority of the deliberations were actually readbacks and judges rereading the instructions. They spent very little time actually back in the room deliberating the case, probably only a couple hours, if you think about it, do the math. So obviously, that bodes well for the prosecution. Whenever you get a quick verdict like this, 99 out of 100 times, you're going to get a guilty verdict on these cases.
Now, this is definitely a political person. Obviously, he's the former president, and a lot of people say that this might have been a political prosecution. Probably 50% of the country feels that way, and 50% doesn't. But these are Class E felonies that he is now guilty of. What does Class E felony really mean in layman's terms?
Well, Class E felony is the lowest level of felony in New York State. You have A, B, C, D, and E, all right? So the E felony is the lowest level of felony in New York State. Carries with it the lowest sentence guidelines in New York State, where you could get a conditional discharge on the low end or 1 1/3 to 4 years in prison on the high end. So in terms of seriousness, obviously this is a president, it's a serious case, but in a run-of-the-mill prosecution, an E felony is not that serious of a case.
And we know there's going to be an appeal. So Barry, if you're Trump's defense attorney, how soon do you file that? What does that process look like?
First, we're going to have what they call a probation interview that he goes through, and every defendant goes through, so that the probation department can tell the judge about his history and make a recommendation. Then we'll get to the sentencing, which right now is in July, but don't be surprised if it gets moved, and especially with the trial date coming up. The defense is going to try to move it.
So you think pushed back? Pushed back,
that they're going to want to farther after the election. But I almost guarantee you right now the appellate team is already working, if they weren't working during the trial, on what issues were preserved, what can we bring on appeal to get that ready to be in a good shape to get an appeal filed as quickly as possible. As John said, these are complicated charges, complicated case. Every ruling that the judge made during the trial is going to be looked at with a fine-tooth comb, and it's just going to be gone through very carefully. But I would expect now we're going to have the sentencing, and then at some point in the future we will have the appeal filed.
But that appeal doesn't delay the sentencing. That's still
Not
going to go forward and will happen then before the conventions.
It should, unless it gets delayed.
Gotcha.
They could try to adjourn it as well. And the defense is also presumably going to bring a post-trial motion where they say that the evidence was not sufficient in front of this judge.
And John, how do you think the jury, when they came out with those couple of questions and 9 hours, do you think that they may have had their minds made up before they went into that jury box? It's hard to tell anything about a jury, but that's 9 hours is very quick for a 6-week case.
Oh, it definitely is. And especially, like I said before, Scott, if you do the math, the 9 hours is whittled down into the majority of that being going back in the courtroom, going back and forth, and hearing judge instructions. So, the time that they actually spent back in the room was very short. So, listen here, it's been my experience that throughout the course of a trial, jurors, think differently as far as when they form their opinion. Are they supposed to wait till the end? Yes. Are they supposed to wait until they get the final judge instructions, get the summations, get all the evidence? Absolutely. But you're talking about 12 human beings. And 12 human beings are all different. And as a human being, sometimes the first impression that you get in an opening statement dictates where you're going to go at the end. Again, bottom line to your question, is it possible that jurors had their mind made up before they went back in that room? Absolutely.
And it's difficult for a former president to get a jury of his own peers because of the political aspect to the case.
Oh, I mean, absolutely. I mean, this case was different in all respects, from the sense that the actual charges themselves, when you are piggybacking upon piggybacking charges, what the last piggyback being a potentially federal charge of a campaign violation, that makes the case difficult. And obviously, who you're dealing with, who the defendant is, made this the most difficult thing we've ever seen in our country.
And so I'm guessing, Barry, that politics can be part of the appeal? I mean, it's part of what they can mention in their appeal?
They can mention anything they want. We fully expect that they're going to, and that has been their position from before the trial, during the trial, now after the trial. We can expect that. But historically, the appellate courts are not going to assume that there's a level of politics that's involved in the case. That will be very difficult for them to set forth. But we'll see what substantive arguments they have, and it's a very complicated case. There were a lot of rulings. The judge gave 1 hour of instructions, and the defense is going to look at everything that they can to see if there's some reversible error to get rid of the case.
Yeah,
real quick.
Everything seemed to be cobbled together, so I know that there are a lot of potential grounds for appeal here because so much of it was really unprecedented. They were breaking
Absolutely.
kind of new legal ground in a lot of ways.
In a lot of ways.
And one thing also, real quick, is that you mentioned that this was the defense attorney's second trial case ever?
That's my understanding. Criminal.
Criminal.
That's my understanding, is that this was his second criminal trial, which
Are
is
you shocked
also
by that?
unusual. Yes, very much so. So if in fact that's the case, I'm very surprised that would be the choice of lead counsel.
Right.
There's no way a prosecutor, a DA, I would never send a young ADA in that courtroom who only had 2 trials. No way.
Yeah.
Well, I mean, as we have seen with Donald Trump, a lot of times surprise decisions and moves that a lot of times kind of defy the conventional wisdom. So again, this time it may have cost him dearly.
Yeah, who knows? Barry Covert and John Flynn, thank you both for your time tonight. We appreciate it. Thank you very much.
Thank you.